Hello, everyone, and welcome to another live session with immigrationquestion.com. So, you've been planning your immigration journey for years, carefully piecing together your application, your documents, and your dreams. And then, with a stroke of pen, a new policy or reform changes literally everything. What does it mean for you? How can you adapt? Well, these are the questions we are here to answer today. Our topic today is immigration updates, how recent policies and reforms may impact you, was thoughtfully designed to guide you in answering these questions and staying ahead. My name is Maliha and I'll be your host for today's session. Joining us today is a seasoned immigration attorney with diverse experience across industries like healthcare, aviation. She founded Direct US Immigration after years at top firms, earning accolades like Northern Virginia and National Black Lawyers Top 40 Under 40 awards. Welcome with me, Attorney Brown. We are thrilled to have you in today's session. Thank you so much for joining us today, Attorney Brown. To our audience watching on various platforms, it's about to get exciting. Grab your notepads and your pens as we get started. So, Attorney Brown, to kick off things, can you walk us through the latest updates on immigration policies and explain how they might affect visas, green cards, and asylum applications?
Sure. So there have been significant developments in U.S. immigration policy that are poised to impact visas, green cards, and asylum applications. So I'll go through about three or four different types of, potential, updates that may occur. The first is the border security mass deportation plan that's been in all of the, news headlines. So President-elect Donald Trump has announced intentions to execute the largest deportation operation in American history, targeting undocumented immigrants worldwide. This initiative may involve deploying military resources and establishing extensive detention facilities. However, logistically, we're really not at that level yet. We do not have enough law enforcement to find approximately 11 million undocumented individuals to remove them from the US. Now, similar along that same vein, they are considering a reinstatement of family detention centers. So plans are underway to reopen these centers when previously there was a shift to avoid family detentions. Another one is a crackdown on sanctuary jurisdictions. So sanctuary jurisdictions or sanctuary cities are basically areas that do not communicate as much to the Department of Homeland Security and ICE when they realize that there's an individual in their community that is without papers, so is undocumented. The incoming administration intends to enforce stricter measures against these sanctuary cities and states that limit cooperation with federal immigration authorities, and this could include withholding federal funds and initiating legal actions to compel compliance. So, one example that the state may find out that an individual is undocumented is if somebody is driving and maybe they don't realize that they can't make a right on a red at that intersection. If they are pulled over by the police and the police find out that they are not documented, the police generally will not contact DHS or ICE in those sanctuary cities. Same with the DMV. So if you are getting, some type of ID, they won't, be as forthcoming with ICE in terms of actually notifying them that somebody does not have status. Now, in terms of the implications for, visa or green card applicants, generally speaking, uh, a lot of the policies are looking to reduce legal immigration. So some of the proposals are expected to decrease the numbers of visas issued, particularly affecting programs like the diversity visa lottery, which, if you're not familiar with that lottery system, it's basically targeted towards countries that have low immigration rates into the US, basically allowing them to enter a lottery to potentially apply for a green card. And then certain employment-based visas like the H-1B, which definitely has been in the news lately, which we can also discuss. But This reduction is aimed to prioritize American workers and address national security concerns. In terms of, whether it affects asylum seekers, the incoming administration does plan to implement more stringent asylum regulations and potentially limiting eligibility and increasing the burden of proof for applicants, which could result in a higher rate of asylum denials and expedited removal proceedings. What we've seen in the past, especially with asylum, and then just immigration in general, is that it takes a while for officers to review asylum cases because of the backlog in the immigration system. We just don't have enough officers to review all the cases in a timely manner. Even in removal proceedings, there just aren't a sufficient number of judges who can review all the cases. So we see some cases, some individuals who are in removal proceedings or previously known as deportation proceedings, but in removal proceedings for anywhere from 7 to 10 years, while others, depending on the level of category, as they do prioritize felons, where they could be in removal proceedings for 6 months to a year. In terms of recommendations to these potentially affected individuals, first and foremost, it is extremely important to stay informed. So regularly consult certain official sources such as the USCIS website for the latest updates and policy changes. Another really big one is to seek legal counsel. So engage in experienced immigration attorneys like myself to navigate the evolving legal landscape and receive personalized advice tailored to your situation. It's one thing to read the USCIS website and maybe understand it or potentially not understand it, but not understand the implications that come because of that regulation. So that's why it's also really good to speak with an immigration attorney. And then in terms of preparing, documentation for filings, just ensure that your applications and petitions are complete, accurate, and supported with comprehensive evidence to withstand that increased scrutiny.
That's fantastic, really. Now, based on your family based immigration, like you mentioned, that has been always a cornerstone for many. How are these new reforms impacting family petitions and reunifications?
Absolutely. So, like you said, family immigration is absolutely a cornerstone of U.S. immigration policy. There are more family immigration cases that are filed with USCIS as opposed to employment sponsored or even investment based applications. So, this is a big one. There could be a potential reduction in family-based immigration categories, increased processing delays, stricter affidavit of support requirements, and potentially changes to the public charge rule, elimination or suspension of certain programs, and then of course there could be an impact on refugee and asylee family reunification, programs, as well as advocacy and legal challenges. With the family-based immigration categories, there are indications that there could potentially be an issue with kind of this area in terms of either deprioritizing or eliminating certain categories, such as the F4, which is for U.S. citizens sponsoring their siblings, or U.S. citizens sponsoring their adult married children under the F3 category. In terms of increased processing delays, when cases have increased scrutiny, so for example, the immigration officers may have to take more steps in terms of looking into their background, their criminal background, their medical background, stuff like that. That could increase the processing time of the case, as well as could increase letters that are sent to the applicants that are basically asking for additional information, and that's known as an RFE, request for evidence. In terms of stricter affidavits of support requirements, so for certain cases like a green card application, there are certain financial requirements for this case. So for example, if an individual is just sponsoring one individual, so their spouse, and their household combined is two. Generally speaking, for non-military members in the U.S., there is a requirement to earn at least 125% of the federal poverty guideline for your household based on where you live. For this, for this incoming administration, they could increase that financial requirement. And to take it kind of a step back, military members only have to earn 100%, where everyone else has to earn 125%. But this could, cause a little bit of struggle for families with modest incomes to meet that enhanced financial requirement and potentially back that reunification. In terms of the public charge that I, previously mentioned, during President-elect Trump's prior time in office, he did expand the public charge rule, which basically impacts individuals who have applied for public benefits, and that may or may not, create more challenges when sponsoring family members. In terms of elimination or suspension of certain programs, the diversity visa lottery, as well as certain family categories, and then also TPS, which stands for temporary protected status. So some of those programs could potentially be, eliminated or suspended. But again, we have to see what will occur once President-elect Trump does come into office. In terms of impact on refugee and asylee family members and that reunification program, a lot of those individuals do sponsor their, derivative family members and follow to join petitions, and there could be new barriers for them to face in terms of potential policies limiting asylum applications, which could then indirectly slow down that family reunification process for asylees, which is already quite slow. And then in terms of advocacy and legal challenges, there will definitely be advocacy groups that are likely to push for maintaining or expanding certain family-based immigration pathways. So, what can we do now?
Mm-hmm.
Although the new administration
Mm-hmm.
will be coming in later this month, you can file your applications or your petitions early on. So now, basically, to initiate those family-based petitions to avoid future restrictions or delays. You can always strengthen your documentation. I'm very much a strong advocate for that. So making sure that you really have comprehensive evidence that is necessary or important for the petition or application to show relationship status or
Mm-hmm.
financial stability, stuff like that. Of course, always monitor policy changes, so stay informed through that USCIS website or consult with an immigration attorney, and then consider alternative pathways. So, for example, if the family member route is taking too long, maybe that family member can be sponsored through employment, or that family member can self-sponsor for an investment visa. There are different options. There are 185 visa categories that an individual can enter the U.S. on. So there are different options and avenues that you could play with. Even a student visa, that could potentially be an option as well. Seems like I may have lost you. So I'll kind of talk about, kind of the employment-based side, on, what new opportunities and what challenges could occur, while we wait for, her to come back on. Oh, there you are.
I'm so sorry about that.
That's
So,
okay.
moving on to our next question. That's quite interesting, Attorney Brown. On the employment side, what should applicants for employment-based visas know about these changes? Are there any new opportunities, any new challenges that they should be concerned of?
Absolutely. So, yeah, so I briefly touched on a little bit of this earlier, but not into full detail. But there are definitely, anticipated changes in employment-based routes through the new administration. So, for example, H-1B visas, which I very briefly touched on. If you've been, anywhere on social media or you know watching the news or anything like that, you've seen that there has been a lot of discourse around H-1B visas, what it is. There are some individuals who are not in agreement with either legal or illegal immigration, and saying that, H-1B visas should be limited or eliminated. And then, what that would look like for American workers to, have those jobs. So there's definitely going to be some increased scrutiny on, some employment-based visa applications with the H-1B visas. And if you're unfamiliar with that, that's basically a visa for specialty workers, and the position requires at least a U.S. bachelor's degree or its equivalent. So for this, there was actually something in the news where a supporter of, less legal immigration said that, the H-1B visas should be limited or completely removed. And Elon Musk hopped in the discourse, as well as President-elect Trump made a comment about it as well. I believe Elon Musk might have come in on an H-1B visa. I believe he might have said that, but whether he did or did not, he does have a lot of companies that sponsor a lot of H-1B visa holders. And it's not just his company. It's a lot of these are tech companies who hire, H-1B workers, as well as our financial institutions. Think of your biggest financial institutions. When you think of banks, you can think of, JPMC or Wells Fargo or Navy Federal, or some of these just larger institutions. A lot of them do sponsor H-1B workers in order to ensure that their operations are running smoothly. If you ask me, I think it's very important to be able to pull money out of your bank if you need to pay something. It's definitely something that is important to me. I'm sure it's important to you as well. So ensuring that there are workers there to keep that business running is extremely important. But with the new administration, there could be increased scrutiny in terms of whether that prospective worker does in fact meet the definition, whether that position does meet the definition of a specialty occupation, whether the employer has sufficient funds to pay the employee. Typically, for an H-1B worker, they are actually paid much more than a U.S. citizen, so it would actually be a benefit for the employer to hire U.S. citizen workers rather than H-1B employers, because because the wage has to go through the Department of Labor to ensure that it is the prevailing wage. So either the wage that the Department of Labor sets, or the wage that is typically paid for that position within that company, whichever is higher. So, there's a lot of misinformation around the H-1B visa, but the H-1B visa is really for individuals in specialty occupations where, maybe the U.S. Just doesn't produce enough individuals in that field, and therefore we have to pull from other countries to, get them into the U.S. Another one is potentially a reduction in visa numbers for certain categories, for certain employment-based green card categories. So, we already see a backlog in the employment-based visa numbers when individuals apply for employment-based green cards. As background, it's not like it's not like certain family-based green card cases where you can always file and then just file for the green card application. With employment-based green cards, there has to be an immigrant visa number available, and that's based on the visa bulletin, which changes on a monthly basis. Now, certain countries are allotted, a certain number of visas, typically in terms of backlogs. Generally speaking, green card immigrant visa number availability for individuals who have Indian nationality or mainland China nationality, Chinese nationals, do have a much larger backlog than individuals in other countries, around the world. So unfortunately, depending on whether there's a reduction in these visa numbers for certain categories, the backlogs could increase. Another thing is expanded opportunities for STEM workers, so science, technology, engineering, math, faced focused workers. So the Biden administration had actually introduced initiatives to attract and retain international talent in STEM fields, which expanded their ability to work as F1 students, F1 visa holder students under their OPT work permit, which stands for optional practical training within these STEM programs. But the initiatives could be reshaped or, deprioritized, reprioritized for skilled immigrants, depending on how the new administration wants to do things. Um, in terms of just general challenges for employment-based applicants, there could be compliance costs, so potentially higher fees, even though there was an increase in USCIS fees earlier last year, technically, in April of 2024, as well as in February of 2024 as well. So smaller employers could struggle to sponsor foreign workers due to that increased financial and as well as administrative burden. There could be issues with public charge and financial requirements. So, again, employers, for the most part, generally have to show their financial ability to sponsor the workers. If it's a new employer, then you generally have to show that you have, potential customers or clients in place that will help to then, will help the company to then pay the worker. And there definitely could be challenges to remote and hybrid work models. So for many employment-based cases, you have to show where the work site is. Generally, the work site has to be, on the premise of the company. However, since COVID, there's been so much, work from home, remote work that, you know, we've had to update, these labor condition application requirements, so these LCA requirements to show that they're actually working at home rather than in the office. So there could be some challenges there. So it's extremely important on these petitions to provide clarity on the exact worksite location, as well as job description, to avoid issues, because for certain employment-based, visas and petitions, there are worksite audits that take place where the government will check the worksite to make sure that that employee is in the correct location and the correct position and being paid the correct wage. It's a way to protect the prospective worker, as well as the company. Now, in terms of opportunities, we've been actually seeing a increase in individuals who apply for national interest waiver green cards. This is basically can be a self-sponsored route to a green card if you work within the national interest. So when you think of national interest, a lot of people think of, healthcare, technology, national security, renewable energy, but there are a lot of other options available that show that show that it is something that is within the national interest of the U.S. And that could include assisting underserved communities, and rural areas as well. So these opportunities do allow for, professionals to self-petition rather than go the traditional employment-sponsored route. Now, there are, other pathways for entrepreneurs and startups, though less used, such as the International Entrepreneurial Program, which basically is a temporary parole for foreign entrepreneurs who demonstrate, substantial potential to grow their business in the U.S. to enter the U.S. temporarily and grow their business. And then, of course, there are other opportunities for expansions of regional centers for the EB-5 investor visa. So there are recent reforms that have revitalized the EB-5 immigrant visa program, providing clear guidelines and protections for investors. And the regional centers are expected to continue facilitating investment opportunities for these immigrant investors. In terms of strategies for these applicants, it's pretty much the same as before. Comprehensive documentation, engage in a skilled legal counsel. So make sure that your attorney routinely practices immigration law in that specific visa that you wish to apply for. And then outside of the normal things that you need to take care of. You can also leverage STEM and high demand opportunities. So applicants in STEM or again high demand fields should highlight their qualifications and contributions to secure priority consideration, and then plan for backlogs. U.S. immigration is not fast. It's I kind of want to say it's never been pretty quick, although there are options for premium processing, but generally speaking, it's not fast. So just plan for there to be some type of delay or backlog, and then also plan that understand that there could be policy changes that monitor. I'm sorry, that change your ability to apply for certain visas or the time frame in which USCIS has to adjudicate the case. So it's always so important to have these types of conversations that assist with monitoring such policy changes.
Mhm. All right, that sounds like a lot of in-depth insight. Attorney Brown, thank you so much for that. And I also apologize for not being able to come on camera. There's some technical issue at my end
No
in my
problem.
laptop. Thank you so much. So, moving on to our audience, again, thank you so much for joining us. If you're just tuning in from any social media platform, we're excited to have Attorney Brown with us today, a respected immigration attorney who has contributed greatly in today's topic. This is immigrationquestion.com, a platform designed to simplify the immigration process. Ask your immigration questions for free in any language and get connected with a verified attorney who can offer legal guidance. You may also receive a free confidential initial consultation. So visit www.immigrationquestion.com and sign up today. So, very quickly, Attorney Brown, for a platform that seeks to aid the immigration journey for every immigrant, both documented and undocumented, by connecting them with seasoned immigration attorney like yourself, what do you think of immigrationquestion.com and what do we do for the immigrant community?
Sure. So it's such a great resource. So, it's companies like yours that really help individuals to understand what their rights are, whether they even have the opportunity to apply for certain visas. And then it's also really helpful to connect individuals to those, specific U.S. Licensed attorneys who can actually do the work. There is such an important role that your company plays in order to be able to connect individuals and to provide more information for free, which we all love. So
Mhm.
yeah, I'm such a proponent of what you guys do, and then just allowing individuals to really understand what they can do in the U.S.
Thank you so much, Attorney Brown. That was a very good, in depth explanation of immigrationquestion.com. Thanks a lot, and really glad to know that you loved our platform.
Mhm.
So this
Absolutely.
is thank you so much. So before we get into the Q&A, just one question I find very interesting looking ahead. Are there any significant reforms or proposals in pipeline?
Yeah, so again, that mass deportation initiative, that is something that is going to be big within the US, although I personally do not believe we have the infrastructure to do it on the full scale that President-elect Trump expects. It is something that we do need to be careful about. So if an individual is undocumented, you need to know your rights. If you're not sure of it, just
Mhm,
Google know your rights
mhm.
on Google and just keep
Right,
that on you.
right,
Uh,
absolutely.
mhm,
Right, so we have a lot of question and answer, like questions coming from the audience, a lot of live questions. If we can address them. The first one coming from Ms. Shania K. Hussein. I want to know if a new visa bulletin will change the wait time from my employment visa priority date. Thank you.
Hi. Yes. So each month the visa bulletin changes, and sometimes it only changes a couple days, and sometimes it will just completely change, and your category will be current. It's extremely important to have your immigration attorney as well as your company monitor that visa bulletin, but you should also monitor it as well. On the visa bulletin, the priority date that your if employment based your I-140 was filed is the date that you need to check for the visa bulletin to see that it's current. Once it's current, I would shoot off an email to that to your attorney immediately so that your company can then, uh, you know, start the process to apply for your green card. So yes, definitely monitor the visa bulletin
Mhm,
and make sure that you're staying
mhm.
on top of it.
Thank you so much for the valuable insight, Attorney Brown. Moving on to our next question from Pamela. Is there an update on DACA program? Can new applicants start to apply?
Yes, so this one is an interesting one because in the past, you know, Trump had been, not so uh, understanding or accepting of, DACA applicants, but I've been seeing a change. Whereas I believe that he's probably understanding a little bit more, what DACA is, how much, individuals in DACA status really do benefit the United States. So I think there will be positive discourse around that in the upcoming election, or I'm sorry, in the upcoming term. So we still need to keep monitoring it, but I think it will be a positive thing. He might even, allow there to be a path to green card status, but don't quote me. But I, I do believe that
Mhm.
there might be some positive movement around that.
Hopefully that there is. Moving
Mhm.
on to our next question from Rejoice. Will a new policy affect the naturalization process for green card holders?
Yes. So technically, a green card holder, when they apply for U.S. citizenship, the officer does have the option to review that entire immigration history to see if there are any problems with it, to then determine whether that individual can obtain U.S. citizenship, whether they cannot obtain U.S. citizenship, or if they will take the green card application away from the individual. Um, the most important thing is to speak with a immigration professional before applying for U.S. citizenship to see whether you qualify, and to also check to see if there's anything in your prior history that might hurt your ability to obtain U.S. citizenship, or to basically to have your green card status removed from you.
Mhm.
But generally speaking, if there are issues, it's best to just renew the green card. But again, that's a super definitely speak with an
Mhm.
immigration attorney directly about your unique situation.
Absolutely, I totally agree with that, Attorney Brown. And if at all we have anyone from the audience would like to reach out to even Attorney Brown, you can contact immigrationquestion.com and we'll definitely love to direct you to her. Moving on to our next question from Suki. If I did not get asylum before, can I reapply under a new policy?
So so that's a tricky one. It really depends on, you know, why your asylum application was denied, whether you're still inside the US, if you have an underlying status, and if you were placed in removal proceedings and an of removal was issued to you. So if if so let's kind of briefly talk about,
Mm-hmm.
say you have status, and you have some type of underlying status,
Mm-hmm.
and you still have that status. Yes, you can reapply for asylum if you have a viable claim, and if you truly believe you're
Mm-hmm.
eligible. You can't just keep reapplying if you don't think you're eligible. If you don't have an underlying status, applied for asylum, the officer couldn't make a decision on that, on whether you qualified for asylum. So then you went to into removal proceedings, so deportation proceedings in front of a judge. If the judge issued an order for you to be removed from the U.S., then you will in fact have to exit the U.S. Once you exit the U.S., if there is, some type of bar because maybe there's unlawful presence or something like that, there could be a 3 or 10 year bar for you to re-enter the U.S., or there could be a permanent bar. So definitely speak with an immigration attorney to see if you could potentially reapply for asylum.
Thank you so much for the valuable insight, Attorney Brown. Moving on to our next question from Mr. Hassan. I am undocumented. Can I still qualify for a temporary protected status?
Yeah, potentially. So depending on the country in which you hold your citizenship, you may qualify for a TPS. There are certain countries that are eligible, so you just need to go to the USCIS website. It's uscis.gov to
Mm-hmm.
see if your country is on one of the
Mm-hmm.
lists. And then, yes, you can apply whether you entered
Mm-hmm.
legally or illegally.
Absolutely. Thank you so much for the insight, Attorney Brown. Moving on to our next question. It's from Mr. Alex. He says, what should immigrations do to ensure we remain compliant with latest immigration laws?
Absolutely. Great question. Always, always, always check the USCIS website so you can actually get alerts from them with updates. You can also, you know, you can also join newsletters, even our
Mm-hmm.
newsletter or immigration questions newsletters to get updates on the policy changes. And then also, if you travel internationally, when you re-enter the U.S., you need to double check your I-94. That's your entry exit record, and that basically tells you how long you can remain in the U.S. If it's shortened for any reason, where your actual visa is has a later date, but your I-94 is shorter, you have to extend your stay for it to meet the visa validity period.
Mm-hmm.
Um, so yeah, it depends on what status you're in and
Mm-hmm.
what your plans are. If you travel.
Right. Absolutely, absolutely, Attorney Brown. Totally agree on that. And we have another question coming from Mr. Gonzalez. Is there a new public charge rule that can affect my application for green card?
So at this time, there is not a new public charge rule. Depending on when you filed your case, there could potentially be a new policy that comes into place, and then that policy will dictate whether it is retroactive to the cases that are already filed, or if it will be, basically start. If it'll be effective based on a certain date and moving forward. So if there is a public charge rule that comes into play, then we'll just have to, review the policy
Mhm.
to see whether it's retroactive or not.
Well, that was the last question for the day. Thank you so much. I believe there's one last question
Sure.
coming from Mr. Thompson. When paying for filing fee for a green card marriage application, should it be money order or debit card, or which is the best one to use?
Great question. There's actually a immigration attorney trick that I
Mm-hmm.
can tell you. So, generally speaking, when you file for a green card application, you've got those government fees that you have to pay. They say that you can pay through a check, a money order, credit card, whatever. I highly, highly recommend paying with a check. The reason why is because when you file your case with USCIS, the, I would say 9.999 times out of 10, they will issue a receipt notice. It is very rare where they will make a mistake and they don't issue a receipt notice for the case. If you uh, if your packet includes checks and the check is cashed, typically on the back of that cash check will be your receipt number, and then you can use that number to track your case. To then reach out to USCIS to ask for receipt numbers and and status of your case, et cetera, et cetera. So don't file with a money order. Don't file your debit card. Use an actual check.
Mm-hmm. Absolutely, that was a quite good one,
Yeah,
Attorney Brown. So that I believe brings us to the end of the session. Thank you so much for joining us, and
thanks so
a
much for having
special
me.
thanks to you for sharing your time and expertise and all the knowledge that you've given to us today.
Absolutely, it's been such a pleasure to be here, and I'm happy to, assist. And I'm always happy to talk about immigration.
Absolutely, it's an honor having you, and we are looking forward to have you back again.
Thank you, thank you. I look forward as well.
Thank you so much, Attorney Brown. Well, we hope today's webinar helped answer your questions and updates. Well, how recent updates and reforms can impact you. Visit immigrationquestion.com to connect with experienced immigration attorneys who can guide you through your journey. If you missed any part of today's session or would like to listen again, the recording will be available on Spotify. To catch today's episode and past ones, just search for Borderless Talk by immigrationquestion.com. Join us next week for another great session on employment based immigration. Once again, thank you, Attorney Brown, for making today's session so exciting. We can't wait to have you back again on
Thank you.
this webinar.
Thank you so much.
You have a wonderful afternoon.
You too. Bye bye.
Thank you. Bye bye. Well, for the audience, you have a wonderful afternoon too, and see you next week. Stay informed and empowered on your immigration journey.